Good afternoon, ladies and gentlemen. I'm your lecturer. I'm taking you on labor laws. I'm giving you lectures. It's on strikes and the law, settlement of industrial disputes. This will be part 2 of the lectures. In part 1, I lectured you whether there is a right to strike. Who is your lecturer? My name is Timothy Abiodun Olatokubo Chubiyele. I'm a legal practitioner. I was called to the Nigerian bar in 1980. I have since then had the opportunity to practice law. I had the opportunity to teach law at the Nigerian Law School. I've had the opportunity to conduct seminars, facilitate workshops involving trade unions, workers, employers or labor over the years. So I will be taking you on part 2 on the topic procedure for settlement of industrial disputes. In part 1, I took you through the right to strike. We define strikes, we define lockouts, we define trade disputes, we defined intra-union disputes. Should we have strikes and lockouts in Nigeria, which is very common today? I concluded in the last lectures that strike is illegal and that solutions to trade disputes is by the round table method as prescribed by law. So today I will be telling you of procedures for the settlement of industrial disputes. One still observes that strikes, even by essential service, is very common today. At the last lecture, we had the definition of essential service being made known to us. Today, we will address procedure for settlement of industrial disputes. One of the steps to be taken when there is an industrial dispute is to look at the collective agreement between workers and employers of labor. The parties should sit down and see how they can settle an industrial dispute by referring to the collective agreement between the parties. If the dispute cannot be settled, the parties can agree amongst themselves or when a dispute is being apprehended, there can be settlement under a mediator. If mediation fails or a trade dispute is apprehended by the Minister of Labor, he may inform the parties in writing or their representatives of the apprehension and of steps he proposes to take. Then there can be the appointment of a conciliator. If conciliation fails, the trade dispute can be referred to the Industrial Arbitration Panel. If an award is given by the Industrial Arbitration Panel and a party disagrees with this award, it can subsequently refer the matter, the dispute, to the National Industrial Court. There are dates framed under the law for the settlement of industrial disputes. The law is that the parties are required first to meet on their own or under a mediator, failing which the commissioner may appoint a conciliator. And when we are talking of the commissioner, is the Minister of Labor. As I said earlier, there are days for the settlement of these disputes. And there are offenses and convictions for parties, employers of labor, worker, or a trade union can be fined for as much as 200 naira. And in case of an employer or an organization representing employers, to a fine of 2,000 naira for breaching the law. Perhaps it's because the imposition of penalties against workers, against trade unions and employers for non-compliance with the provision is not sufficiently punitive. That is why employers of labor and employees will go ahead and breach the law. So these are the procedures laid down. If these procedures are followed, it will ensure that we have industrial peace. The Industrial Arbitration Panel consists of a chairman, a vice chairman, and not less than 10 other persons, all of whom are appointed by the Minister of Labor. The president of the Industrial Arbitration Panel is a legal practitioner and is assisted by other members who are versed with the operations and the laws guarding workers and employers of labor. When a matter is referred from the Industrial Appropriation Panel to the National Industrial Court, the award of the National Industrial Court shall be final and binding on workers to whom it relates are from the date of the award. It's only in exceptional cases that the dispute is referred to the Court of Appeal. I will now be telling you later on circumstances that we afford such a reference. So these are the procedures of the law. If these procedures are followed, we will not be hearing of strikes, and there will be relative stability and peace, industrial peace in the land. What is the role of the legal practitioner in the settlement of a dispute? Each party to a dispute may appear by its legal practitioner. A board of inquiry may also be set up under Section 33 of the Trade Dispute Act when a dispute exists or is apprehended by the Minister of Labor. These are all procedures for the settlement of industrial disputes. Then what has the jurisdiction of the court in trade disputes and intra-union disputes? One of the challenges posed in trade disputes is that sometimes parties rush to the normal courts, the state, the federal high court, to seek one injunction or the other. For as far back as 1992, under the Trade Dispute Amendment Decree of 1992, the decree provides that the International Industrial Arbitration Panel and the National Industrial Court will treat all disputes in the country. There is, however, a provision for appeal to the Court of Appeal on questions of fundamental rights. That is as far back as 1992. Amongst other things, makes any interim or interlocutory order, etc., made prior to the commencement of the decree in trade dispute matters of no effect. The provisions of the Trade Dispute Amendment Decree 1992, excluding calls from hearing trade dispute, is now provided for in Section 2, Trade Dispute Act, Cap T8, Laws of the Federation of 2004. In the case of Gabriel Falade, Adiaga Musliu Okweagbe, a judge of the Lagos High Court, refused to hear the teachers' trade dispute, declaring jurisdiction by virtue of Section 47. The Supreme Court in Udo versus Orthopedic Hospital Management Board and another, in constructing Section 1A of the Trade Dispute Amendment Decree number 47 of 1992, the Supreme Court held, let me quote, by virtue of Section 1A of the Trade Dispute Amendment Decree number 47 of 1992, no action relating to trade disputes, whether intra or inter-union dispute, can be commenced in a court of law as from the commencement of the decree on 1st January 1992. The jurisdiction of court in respect thereof is ousted. Also, actions pending in court as of 1st January 1992 will abate and will be null and void. The decision in Daniel versus Faduba has also been followed in other cases like NURTW versus Ugodo, Ifezua and Madupa, Ekong and Osaide. So all of this is to ensure relative peace. You can't just rush to the High Court to obtain an injunction or to override the Industrial Arbitration Panel or the National Industrial Court. Let me also refer you to another case, Tidex versus Nupe, where it was held that by virtue of Section 1A of the Trade Dispute Act, as amended by Decree 47 of 1992, no person shall, subject to Section 20, Subsection 3 of the Act, commence any action, the subject matter of a trade dispute, or any intra-union dispute in a court of law, and accordingly any action which prior to the commencement of the section is pending in any court of law shall abate and be null and void. Any interim or interlocutory order, judgment or decision made by any court other than the National Industrial Court in respect of any trade dispute, inter or intra-union dispute prior to the commencement of the section shall cease. The mischief aimed by the Trade Dispute Amended Decree of number 47 of 1922 is to avoid the proliferation of trade union cases in several high courts and ensure that litigation is in the National Industrial Court only. So, this particular law has ensured, to some extent, industrial peace. Appeal shall lie from decisions of arbitral tribunal, An appeal shall lie from the decision of arbitration tribunal to the National Industrial Court as of right in matters of dispute specified in subsection 1A of section 7 for National Industrial Court Act 2006. Then there is also the international best practice in labor or industrial relations. The court is enjoined to enforce international best practices in labor and industrial relations. I would like to refer you at this point to a book that is authoritative also in labor law, the book by Rucheba's Labor Law Manual by Enelbong Ete, where there are conventions of international labor law, ILO, which can be applied to fulfill the international best practice requirement. Appeal from the National Industrial Court. Let's look at the provisions of Section 9(2) National Industrial Act 2006. Subject to the provisions of the Constitution of the Federal Republic of Nigeria and subsection 2 of the section, no appeal shall lie from decision of the court except in matters as prescribed by the Act or any act of the National Assembly. So this tells us, except in exceptional cases, the National Industrial Court is the final court for the settlement of industrial disputes in Nigeria. Then there have been some debates over the years on the jurisdiction of court in trade dispute matters. I would like to refer you to the case of Kalango and Dokubo. The Court of Appeal held in Kalango and Dokubo, Ogebe JCA dissented, that in spite of Decree 42 of 1992, the High Court could entertain a matter bordering on trade disputes. I will tell you later other subsequent decisions after Kalango and Dokubo. What are the rules applicable in the National Industrial Court? There is the National Industrial Court of Nigeria Civil Procedure Rules 2017. Then there's also a question that has raised but has recently been settled by the law courts, whether the National Industrial Court is a superior court of record under the Constitution of the Federal Republic of Nigeria 1999 as relates to jurisdiction of court in labor matters. Let us look at the case of National Union of Electricity Employers and another versus Bureau of Public Enterprises, where it was held by the Supreme Court. Let me read out what was held in that case. The provisions of Section 47 of 1992 arrogating to the National Industrial Court a superior court of record, as has been contended by the appellant, does not by that token make the said National Industrial Court a superior court of record without due regard to the amendment of the provision of Section 635 of the 1999 Constitution, which has listed the only superior courts of record recognized and known to the 1999 Constitution, and the list does not include the National Industrial Court. Until the Constitution is amended, it remains a subordinate court to the High Court. In Kalango versus Dokubo, for instance, the Court of Appeal said that though the National Industrial Court is not one of those specified in Section 6.5, 1A1 of the 1999 Constitution as the only superior court of record, it is nevertheless not an inferior court. It is become a superior court of record by virtue of an amendment to Section 10 of the Trade Dispute Act, Decree 47 of 1992. But in the case of Attorney General of Oyo State versus Nigeria Labour Congress, all courts of appeal could say is the National Industrial Court has the status of a superior court of record. You can read up this case. Some of these cases I cited in the course book for this subject, Labor Law and Practice, which I authored. There are so many other cases in which this controversy has been ongoing. There's the case of Adisa versus Onyiwola, Ekong versus Uside, where it was read, it is difficult to read unconstitutionality to the status that created the National Industrial Court. The Court of Appeal now has the jurisdiction to hear appeals from the National Industrial Court due to the alteration of the Constitution by Section 4 of the Constitution of Federal Republic of Nigeria, Third Alteration Act of 2010. It is understood that an appeal shall lie as of right to the Court of Appeal from the decision of the National Industrial Court as relates to questions of fundamental rights as provided for in the Constitution on matters which the National Industrial Court has jurisdiction. So, those are circumstances in which there can be an appeal from the decision of the National Industrial Court. In this short lecture, the details of all I would love to say, this lecture might not be able to accommodate it. I will be referring you to a book I regard as the course material on this subject. That is the book Labor Law and Practice by T.O. Tugulu. I authored this book. It will help you to have a grasp of labor law and practice in Nigeria. If you cannot find this book, we also have it in our digital law research platform, the Law Master. You can download the Law Master mobile in your Android phone for now, your iPad, your tablet for now, and you can download the Law Master Unlimited in your laptop or desktop. You will find this book and some other law research materials and books in the Law Master digital library. Then, what is the jurisdiction of the National Industrial Court when one of the parties is an agent of the federal government of Nigeria? When one of the parties is an agent of the federal government of Nigeria, the Federal Industrial Court has the jurisdiction to hear the suit. Let us look at Section 251, Subsection 1, Q, R, and Subsection 3 of the Constitution of the Federal Republic of Nigeria. The court, however, should look at the subject matter of the suit. Look at the Supreme Court case of NEPA versus Edengbero on the Constitution, on the interpretation of Section 251 of the 1999 Constitution vis-à-vis the power conferred on the National Industrial Court under the Trade Dispute Act, Cap 432, Laws of Federation 1990. It has been held, let me quote from that law report, for the High Court to be competent to exercise jurisdiction to hear the suit under Section 251 of the 1999 Constitution, one of the parties must be a federal government agency, and the subject matter must be an action seeking declaratory relief or injunction against the executive or administrative acts of the federal government or any of its agencies. This was what Adekeye JSC said in that particular decision. There are so many other cases which time will not permit me to deal with during this, but I can refer you to the case of Olorutoba Oju versus Abdul Rahman, 2009, 7 Nigerian Labor Law Report, Part 48, page 301 at 353. Look at what the court has to say in this case. It's also the case of Kalango versus Dokubo. It is my submission that where a party is the federal government of Nigeria or its agency, and the subject matter of the litigation has to do with administration or management and control of the federal government, the Federal High Court has the jurisdiction to hear the suit. Look at Section 230 of the 1979 Constitution or Section 251 of the 1999 Constitution, and to cases that I've earlier referred you to. NEPA versus Ndengboro, Olorutoba Oju versus Abdul Rahman, Obia Wuobi versus CBN. These are all cases I will refer you to. Go and look into them as to the jurisdiction of the Federal High Court. So you will see there are ample provisions in law for the settlement of industrial disputes. Strikes should no longer be mentioned in Nigeria. People can sit down and look as the way of resolving matters. But some people will still want to justify strikes. Apart from what the law has described as a strike, let us look at what Lord Denning has to say about what strike means. He said, strike is a concerted stoppage of work by men done with a view of improving their wages or conditions of employment, or giving vent to a grievance or making a protest about something, or whether or supporting or sympathizing with other workmen in such endeavor. It is distinct from a stoppage which is brought about by an external event such as a bomb scare or by apprehension of danger. He said this in the case of Tramp Shipping Company versus Greenwich Marine Incorporated, 1975. Similarly, there is a definition of strike, as we have earlier pointed out in part 1 of our lectures. So, what do we call work to rule? The act, when you have a close look at the work to rule is a strike. The act defines the term cessation of work and refusal to continue to work as used as the cessation of work includes deliberately working at less than usual speed or with less than usual efficiency, and refusal to continue to work includes a refusal to work at usual speed or with usual efficiency. So if you do if you go on an action that you refer to as work to rule, you are on strike. And under Nigerian law, as I've stated, there are offenses for the punishment of strikes. Then let's look at the right to picket. Let's look at section 42, subsection 1A. The existing provisions already emphasizes that for picketing to be lawful, it must be done peacefully. Hence, the word peacefully is used twice to qualify obtaining or communicating information and also persuading any person to work or abstain from work. How about non-striking workers joining in strikes? Subsection 1, paragraph B, seeks to protect non-striking members of the society from being compelled by strikers to join in the strike action. This is not all. The subsection further seeks to secure the free movement on land and air of non-strikers during the period of a strike. That means people go on strike cannot go to the major roads and block the passage of vehicles, as some do. You can't prevent planes from flying, as some will do. You can't keep aircraft from flying. You can't object the public highway. There are criminal sanctions for embarking on strikes. Look at Section 7 of the 2005 Amendment Act. Provide for criminal sanctions of 10,000 naira or 6 months imprisonment for embarking on a strike. There are justifications for strikes. I will refer us to some learned authors. Oladoshu Oguniyi, in his book Nigerian Labor Law and Employment Law in Perspective, Otto Ram Freeman and Bob Harpo on this critical subject, to some extent, they support strikes. I will not, time will not permit me to go to read out what all these legal authors will have to say. But as I round up, much as a roundtable approach is advisable, it could be time-consuming. Considering the powers trade unions bodies have in places such as the United Kingdom, that has been used to shape the economy and the society, one might not be able to rule out strikes. However, the time lag in the settlement of trade disputes has the effect of cooling tempers and thus ensuring industrial peace. The Trade Dispute Act provides a situation where the economy of the country may not be ground to a halt, and a situation of chaos in the events of industrial action in the sector of essential services provisions. In respect of criminal sanctions, from the degree of penalty, but from the social stigma attaching to them, if the event of criminal sanctions is to produce exclamation, their criminal value is not only lost, but is reversed. I want to conclude that in order to ensure industrial peace, the procedure prescribed by the law should be adhered to. There are other strikes that should not be heard of in Nigeria, which is common occurrence. Politically motivated strikes. I call them politically motivated strikes. Like the Alveolar Crisis in Nigeria in the 90s that ground the economy of Nigeria to a halt. There was a presidential aspirant, Chief MKO Abiola, now late. He lost. He supposedly won an election, which was annulled by the military head of state. Then the labor unions went on strike and grounded the economy of Nigeria. That type of action is not related to a trade dispute. That is a politically motivated strike. Such must not be heard of in Nigeria. Can trade unions embark on strikes which are not the basis of a trade dispute? My answer is no. Trade unions employers of labor should seek ways of settling industrial disputes through a round table. Thanks for listening to me. I'm sure many people will want to comment about this. We are opening a WhatsApp group. We will make it public now. We already have it. You can go to the WhatsApp group. We will supply you the links much later where you can make comments. Other people who listen to this video and listen to this lecture will want to join us. I still have so much to say about labor law. Subsequently, after this part 1 and 2, we will be having other lectures on labor law. Thanks for listening to me. Good day.